Hi, everyone. Good morning or afternoon, depending on where you're joining from. My name is Megan, and I'm a part of the EarthxCapital team here at EarthX. And we are super excited to welcome you to our EarthxCapital webinar today, which is navigating the patent and trademark process with the United States Patent and Trademark Office. So this is one of actually, we're really excited because it's essentially one of our kickoff webinar for a webinar series that we're launching, focusing on the innovation and investment ecosystem. So this is one of hopefully, or what will be several to come, and really, really excited that you're here joining us. And even more excited to welcome and introduce our speaker today, Ms. Hope Shimabuku. So she is very well respected in the innovation, or a very well-respected leader in the innovation ecosystem. Vikram who's the senior director, Vikram Agrawal, he thinks the absolute world of Hope, as do I. She's spoken at our eCapital Summit before. She's just a wonderful, incredible leader and does a lot with the USPTO. So she is regional director of the Southwest Regional Outreach Office at the USPTO. And we'll be sharing a lot of wonderful insights today on intellectual property, fundamentals, and different resources that will hopefully be very useful and such as well. So just to give a heads up of how the formatting will work today, Hope is going to present and share, and throughout we will have some time for Q&A. We'll look periodically at the chat. If you have a question, you're welcome to enter it in there, which I'll be moderating, and Hope will answer those questions, and we'll also have some time there at the end. So really, really appreciate you joining today, and I'll send it over to Hope.
All right. Thank you, Megan, for that very warm introduction. And thank you to Vikram as well for including me in this presentation. And so, as Megan mentioned, I am going to be talking about intellectual property and navigating the USPTO with respect to patents and trademarks, and also some of the other buckets of IP that we don't manage directly. But I'll give you an overview about who the USPTO is, and then I'll dive into the different buckets of IP, and then end with a presentation on the different resources that the USPTO has. And as Megan mentioned, I will be pausing strategically throughout the entire presentation to be able to take some of the questions that you have. So feel free to type into the chat, and also just go ahead and ask your questions, and note that you don't have to wait till the very end in order for your question to be answered. Although sometimes I may indicate that I will be coming up to the presentation and I will be describing it a little bit more. Okay. And so with that, I wanted to kick it off by letting you know that the U.S. Patent and Trademark Office is actually the oldest agency in the United States. And the reason that it is the oldest is because the rights that we grant are founded in the United States Constitution. Specifically in Article 1, Section 8, Clause 8, Congress has given us the power to be able to give, for a limited time period, essentially a monopoly to authors, which is actually technically associated with writings and overseen by the Copyright Office, but inventions as well, and discoveries, which are going to be granted to inventors. The USPTO, we are located in Alexandria, Virginia, and our entire organization has over 14,000 employees. The lion's share of our employee base is actually patent examiners. So 80% of our organization is dedicated to examining and reviewing patent applications that are coming in. We also have a relatively large cadre of trademark examining attorneys, and we'll talk a little bit about what a trademark is and what they're reviewing. But we also have judges and other administrative staff that are associated with the USPTO. Our 14,000 employee base is actually located nationwide. And so we have employees all throughout the entire United States, including the territories in the Virgin Islands, as well as Puerto Rico. Every year, we receive an increasing number of patents and trademarks. And so last year, we received about 664,000 patent applications. And we also received about close to 770,000 trademark applications. Each year, there is a steady increase on the patent application filings, about 1 to 2%. And on trademarks, we usually see 4 to 5% increase, and sometimes even more based on how well the economy is doing. There is a tie between intellectual property and the economy. And when the economy is doing well, then we see increased filings, particularly in the trademark front, because businesses are opening, there are new products or new services that are being developed. And so applicants are applying for trademark protection. And so usually trademark filings is a leading indicator for us on how well the economy is doing. As I mentioned, the USPTO, we are actually located in Alexandria, Virginia, but we also have a number of different regional offices throughout the United States. I myself am located in the Dallas, Texas regional office, but we also have regional offices in Silicon Valley, San Jose, Denver, as well as Detroit. We also have a community outreach office, which is a smaller office for us, and it's located out of the New Hampshire location. Our Southeast office, which recently opened up, that is actually being managed out of our headquarters office in Alexandria, Virginia. What you see here is a map of what we call outreach coverage. So if there's events like this, stakeholder meetings or stakeholders that we're going to be engaging with, the office in which that is covering that particular state is going to be the primary point of contact for that state. What is not covered in here is who is actually going to be reviewing the applications. So if you're in Texas and you are filing a patent or trademark application, the examiner who's going to be reviewing that application may not necessarily be located in my office. The patent examiners, they will review applications based on the technology area because they are a subject matter expert in that technology area, and they could be physically located anywhere in the United States as well as in Puerto Rico or the Virgin Islands. Same thing on the trademark side, except trademarks is a first in, first out. And so whatever is the next application in the queue is the one that they are going to be reviewing. Again, they could be anywhere in the United States. So our office, as I mentioned, is located in Dallas, Texas. All the regional offices are similarly structured, and the different services that we provide are very similar across the board. We have events that we host on-site, courses that are similar to this, and other different types of courses that we might hold. We do have opportunities for you to attend those in person if you choose to. We also have a public search facility. So if you are looking and you need some additional help on doing a patent search or a trademark search, we do have terminals that are on site so that you could use them to actually search, but also get hands-on help in person if you decide to come in to get the advice for that. We also have hearing rooms. And so if you are in the application process and you are at the point that you might want to appeal or have something heard in front of our patent trial and appeal board or trademark trial and appeal board judges, you can also do that in person. Or if you just want to come and listen in on an ongoing proceeding, those are things that you have the opportunity to do in person as well. Lastly, if you just want to meet with me or anyone on my team on a one-on-one session, you can either come in person or you can actually set up an appointment and we can do a virtual session like we are doing currently right now. But all of this information and our contact information can be found on our website, and the link is located here. And so with that, I am now going to get into the nuts and bolts and the substantive portion of intellectual property. And so when you're thinking about intellectual property and you think of the words themselves, intellectual is anything that you have come up with, that you have developed, and you have created it. It's a new invention, a new widget, a new business that you have come up with and created in your mind. And now it's being converted into a property right. And so just like your house or a car, you can do the same thing with intellectual property as you can with a house, which is considered real property, or a car, which is considered tangible property. Tangible property is anything that you can touch and feel. Intellectual property is something that you cannot touch or feel, so it's considered intangible property. But you can sell the intellectual property, you can give it to your family, friends, brother, sister, parents. You can license it, or you can rent it out, but in intellectual property terms, it's considered licensing. So anything that you can do with other property that you think of, you can also do with intellectual property because it is an asset. It's just an intangible asset. So let's take, for example, a mobile phone. And I'm going to go into each of the buckets of intellectual property that is described here in more detail, but I want to give you a broad overview using the example of a mobile phone. The mobile phone that you actually see here is a Samsung phone, and specifically the product is a Galaxy Note. A trademark is the IP bucket that protects the Samsung name as well as the Galaxy Note. It is what we call a source identifier. It tells you who is providing the goods or services of a particular product. And so in this particular case, when you see the Samsung name or you see the Galaxy Note, you know it is a smartphone that is developed by Samsung. Patents. So there are thousands of patents that are actually embodied within this actual phone. So the typical patents that you might think of is what we call utility patents. And so those patents can be things that are related to the camera, the battery, the screen, antennas, data processing method, or semiconductor circuit. All of those are probably protected, and those components protected in this particular phone, as well as several thousand other patents that are embodied in this phone as well. Design patents. Design patents are patents that are associated with the look and feel. And so it is what we call the ornamental features of the actual patent itself. So examples of that can include the shape of the home button, or the curve of the bezel, or the curve of the screen. All of those can be protected by a design patent. Copyright. That's probably the most well-known bucket of intellectual property, as we've heard as we're growing up in school. That's copyrighted, so don't copy that particular book or the language or portions of the book. That is covered by an intellectual property bucket. A copyright is an original work. Typically, there has to be an artistic component to it, but it is embodied in what we call a tangible medium. And so let's take software code, for example. Software code, it's written, right? And it is an original work. The courts have recognized it as being artistic. Software code, once it's saved into a hard drive or a memory device, that's the tangible medium. And so then the copyright arises from that. Instruction manuals, hard copy or soft copy. Hard copy, it's printed on a piece of paper. That's the tangible medium. Soft copy, again, similar to software code, it's saved on some sort of hard drive or memory device, the tangible medium, so a copyright can exist for that. Ringtones, very similarly, either the musical score itself, whether it's soft copy or it's hard copy, or it's the actual ring tone, right? Once it's saved into a memory drive or a memory device, a copyright exists with that. The last bucket of intellectual property is a trade secret. A trade secret is anything that there is economic value for keeping it secret. Now, we believe and we know that there are trade secrets that are included within this particular Samsung phone. The only thing is we don't know what they are. Why? Because it's a secret, right? And so those are things that we are not aware of, and they're not actually filed with any government entity. All right. Before I go into a deeper dive in patents, I want to take a quick pause to see if there are any general questions overall. And there may not be. Okay. Since I don't hear Megan popping on to say that there are, oh, okay. I see you.
Yes, looks
Yes.
like a question just came in from Derek. What if a patent evolves?
Okay. So that's a really great question, and I'll dive a little bit into it. And so, a patent is an invention, and if a patent has been granted at a certain period of time, it's good for 20 years, and you're given a monopoly for 20 years. And so, if the patent evolves, in which there's a new version of that, or there's an improvement thereof, um, a lot of times the inventor or the organization will also file a patent on the evolution or the improvement of the original patent itself. It's very common. And so 80% of the patents that we actually receive are improvements on the previous patent before. All right. Did that answer the question? Is that a different?
There's, yes, a follow-up. Is that a different name of the patent then, or type of filing?
It can be, and it just depends on what your strategy is. Okay, so you can file a completely new patent, right? But sometimes, based on the strategy of what you want to do, is you can file what's called a continuation or a continuation in part, which means that you're using the previous patent as a basis. And then now, so one of two things happens, right? One is that, hey, you have a patent and you have things that are called a claim. The claim is actually the legal description of your invention. So your claim has claimed a certain portion of what's actually described in your patent, but you may find out that, hey, you want to claim other things, right, that were described, but you may not have put it in the claim. So you might want to file a continuation on the previous patent, but claim some of the unused portion of that patent. Another way that you might want to do it is you'll file what we call a continuation in part, in which you still have the base patent, but now you've made an improvement on it, right? So you have new information. So you'll file another patent so that you can include that new information on it, but it's going to be based on the previous patent. Now, the reason that you might want to base it on the previous patent is because you want to prevent anything that was filed after the date of the filing date that you had submitted with the original patent. You don't want anything new that has come in to be a block on the patent that you are filing. So sometimes that's like a strategic decision on why you want to file and use the continuation or continuation in part, as opposed to a brand new patent when you are filing with us. Okay.
So
All
hope we've
right.
had a couple other questions come in.
Okay.
So one is there a publicly available database for trademarks and patents?
Yes. So if you go to our website at uspto.gov, all of the patent applications that have been filed at least 18 months, right? So we can't disclose patents that have been filed less than 18 months. But any applications that have been filed and have been granted, they will be on our website. Same thing with trademarks. Trademarks doesn't have that 18-month time frame in which we have to wait in order for it to be disclosed. So all of that is actually on our website. You can search for both patents and trademarks on our website.
Awesome. And then another that's come in. So someone says recently they've heard mixed comments from attorneys as to whether starting the patent process with a provisional patent is a good strategy. Do you have any thoughts?
Okay, let me put a pin on that one because I'm going to talk, because I'm not sure if everyone knows what a provisional patent application is. So I will talk about that in a little bit. So let me put a pin on that question.
Perfect. And then if you'd like, Hope, I can continue reading some questions, or maybe if you want to continue with the presentation, we can come back to some of those as you prefer.
Okay, yeah, why don't we do that? Let me move forward with patents, okay? Okay, so as I mentioned before, the most common patent is what we call a utility patent. This is what we typically think of. As you can see, what's pictured here is the light bulb from Edison. This is what we typically think of a patent. A patent is something that we at the US Patent and Trademark Office are able to grant to you. And it's what we call an exclusionary right. It doesn't give you the right to do something, but it prevents others from doing something without your permission. And so, what are the things that someone cannot do without your permission? It excludes others from making, selling, using, offering for sale, or importing that particular invention described in the patent without your permission. And you have the rights and the full monopoly to that for a 20-year time period. And it's really kind of an exchange in order for us to be able to promote science and the innovative arts. And so, what that really means is that we're advancing technology by giving you a monopoly for a certain period of time. And then you, in exchange, are sharing your ideas and your inventions to teach the public and let them learn about your invention as well. Patents are territorial, so the patents that we grant are only good within the United States and the territories covered by the United States. If you wanted a patent from another country like Canada or Mexico, Europe, or Asia, you'll have to go to their specific patent offices in order to be able to get a patent. Same thing with any of the other intellectual property buckets that I'm going to talk about as well. In order to get rights in any of the other countries, you have to go to our sister agencies around the world to be able to get that. And patents protect anything that's new, useful, and non-obvious. And so what are the things that can be protected? It can be a process, machine, manufacturer, composition of matter, or an improvement thereof. And I'll give you more of an example in a minute, okay? And so a utility patent, as I mentioned, is the most common, and it is good for 20 years from the date that you actually file within our office. And so what are some of the things that you can patent? Specifically, you can patent something that's a process, machine, article, manufacturer, or a composition of matter. So let me give you an example, and let's use a shoe, for example. And let's say you have developed a new sole for that shoe. And that sole is really cool because it whisks away the sweat. It is really super soft and comfortable when it's inserted into the shoe. So you have come up with a new composition of matter in which that particular material, you have combined different molecular cells and different things in order to develop a new product and a new material. And that is something that could be patented and considered a composition of matter. Now, let's say that you want to put this sole and you are going to actually put it into a manufacturing process. So, for example, you're going to take the sole, you're going to take the heel, you're going to put some glue on it, and then you're going to put the sole on top of that. You're going to take the fabric, you're going to sew it on, and then you're going to insert the shoelaces after you punch the holes in there. So that entire process, that manufacturing process, may also, if it's new and not something that is obvious, you can also possibly patent that. If you have a machine that can mold that particular shoe, or sole, excuse me, then that machine can also possibly be patented as well. So there are different types of patents and different things that can be covered by a patent, and those are some of the different examples of a utility patent. Design patent. As I mentioned before, with the Samsung phone, a design patent is the look and feel. It's the ornamental features. What you see here is a bottle, specifically a root beer bottle, and the shape, the clover shape that you see right here, or let maybe it's not clover, but anyways, this shape right here is what is being protected in a design patent, look and feel. The last type of patent is a plant patent. And so a plant patent is anything that has some sort of human intervention in order for that plant to be developed. A plant patent cannot be naturally growing. And so you can't go outside and find a blade of grass or a tree that is naturally growing in and of itself and then apply for a patent. There has to be some sort of human intervention so that it can be asexually reproduced. And an example is shown right here, which is the poinsettia. The red poinsettia is and has received a plant patent from us. So this is where I'm going to talk a little bit about the provisional applications, which is associated with that particular question. So a patent is good for 20 years, but the patent that's good for 20 years is what we call a non-provisional application. That is the full-blown patent that has to be filed with us, and only a non-provisional application can become a patent. Now, there's a step that's before that, and there's an optional step, which is called the provisional application. And that is a shorter application, and it's really what we call a placeholder in time. So whoever is the first person who actually applies or files for a patent with our office, they are the one that is able to receive the patent rights. And so sometimes a provisional application is a placeholder that people will file in order for them to secure the rights. Now you have 1 year to convert that provisional application into a full-blown patent application so that you can go ahead and get the full patent. But the date that you will secure is the date in which you file your provisional application. Now, why would you want to file a provisional application? Sometimes what would happen is, like when I was in-house counsel, sometimes the provisional application, you want to file it because you're not ready for the non-provisional application. I would often get a call from the engineering team or the marketing team, and they would tell me, hey, Hope, I want to file a patent. I have this invention, and I want to file a patent application for this. And I tell them, like, great, when is your launch date? And they'll tell me tomorrow. And believe it or not, it takes more than a day to prepare a patent application. And so in those types of scenarios, I want to make sure that that particular invention is protected. And so what I'll do is I'll file a provisional application. It's quicker, and I can get that in a very short time frame. And then I can do the further investigation and to be able to develop the actual provisional application or non-provisional application. Sometimes organizations will want to file a provisional application, especially small businesses and companies, because they're not sure if their idea is going to take off. But they want to have the idea protected so that no one else can take their idea and file the application and then receive the patent at the end of the day. A lot of times when you go to pitch competitions or you go and talk to other venture capitalists, angel investors, sometimes they may not sign a non-disclosure agreement. And so sometimes you want to take steps in order for you to protect your idea. So you might want to file the provisional application. It's not as expensive. And then if the idea has some sort of traction or footing, then you'll go ahead and file the non-provisional application. The last reason that sometimes people file a provisional application is to get the patent pending status. A provisional application or the filing of a non-provisional application will allow you to get the patent pending status. And sometimes that gives you a foot up in the funding process. Our statistics actually show that if you have a patent pending status, then you are 70% more likely to be able to secure funding in the seed rounds as you are going through the process of securing funding. So those are some of the reasons why people file for provisional applications. I'm not sure if that totally answered your question, but I think it did. So I'm going to take a quick break to make sure I answered that specific question, or if there's a follow-up to that. Okay. All right. I must. Okay. All right. Thank you. Okay. So I just wanted to show you some fun patents. Sometimes it can be really dry to go through patents, but we have some weird and wonderful patents that have been filed and granted by us. And so in this particular patent, it's a TV control device, and it can be used to adjust volume. It's more comfortable. You can do this from the comfort of your sofa. It has a variable adjustable length and considerably less expensive and functions effectively. All right, does everyone have what this is in mind? And keep in mind, these are actual patents that have been granted. All right. So in 1976, this was the TV control device that was developed for the old time TVs, right? That had the turn knob. You may have had to hit the TV a couple of times to make sure that the static goes away so that you get a good signal. But this was something that was actually filed with our office. A fresh air breathing device and method that makes it possible to breathe in a smoke-filled room while waiting to be rescued from a hotel fire. It enables the user to breathe fresh air through a tube. Okay, got it? All right, is this what you were picturing? I'm not so sure. I would argue that this is truly considered fresh air if it's coming from the toilet. But I do know that this was something that was illustrated in, or shown in The Kingsman. And so it was included in a movie. All right, very last one. A pet umbrella and leash. It is a must-have pet gadget that combines a pet umbrella and a leash. It will protect your pet from inclement weather conditions while also serving as a leash for pets. Okay. Now, this device actually is something that you can buy on Amazon, in case you were wondering. And so if any of you are interested in it, you can get your own pet umbrella and leash. All right. I am now going to move into trade secrets. And for the interest of time, I'm going to go through trade secrets, and then I'll see if there's any questions. And then from there, I can move into the other buckets of intellectual property. Okay. So a trade secret, as I had mentioned, is anything that has economic value in keeping a secret. The key to this is that you have to, if you have a trade secret, you have to take reasonable steps in order for it to be maintained as a secret. And so the most well-known trade secret is Coca-Cola and the Coca-Cola formula. And I say it's well known because a lot of people know that it is a secret recipe and a secret formula. Supposedly, the recipe is written on a piece of paper, it's torn in half, and then it's stored in two separate safes. And each person, there's two people who have the combination, but each person does not have the combination to the other. I don't know if that's really the true story, but that's how Coca-Cola has been able to keep this particular recipe as a secret. Now, some of you may be asking, well, hey, on the back of a Coca-Cola can, it tells me all the ingredients that are associated with the Coca-Cola formula. So why is it a secret? Well, what you don't know is the order of each of the ingredients that is being added. You don't know the temperature and then the pressure of what the formula is being cooked at. So all of those different things we don't know. That is the true secret. Now, there are others like Pepsi who have tried to copy or reverse engineer the Coca-Cola formula, but they have not been successful at it. And so as a result, they've been able to keep that secret a trade secret. Now, a trade secret can last forever or for life. As long as it is kept a secret, then that is something that is an intellectual property bucket that will last forever. Krispy Kreme, their donuts, they have a trade secret for that. The secret spice in the Kentucky Fried Chicken, that is also a trade secret. Google has a trade secret on their search engine. What we don't know is after you enter in whatever you're going to search for on the Google search engine, we don't know how the search engine determines what's going to come up first, second, or anything else as they are searched on the list. So that is something that Google has maintained as a trade secret. So patents and trade secrets are considered polar opposites when it comes to intellectual property. And so when you're trying to decide at the end of the day which bucket you are going to use to protect versus patents versus trade secrets, those are usually the ones that you are going to be considering. Now, a trade secret, if you are able to reverse engineer something and you have not stolen any information from another company for their trade secret, if you have legitimately reversed engineered it, then you have not violated that trade secret. You are free to use it if you've figured it out on your own. And so if something is able to be easily reverse engineered, oftentimes people will consider to patent it, because in a patent, you're already disclosing your invention and the know-how that's associated with it. And so you'll get a monopoly for a very short period of time. But if it's really easy to reverse engineer anyways, at least you already have that protection and it's protected under a patent. Listed on the slide is also some other reasons why you might want to consider patents versus trademarks. But the primary determination or the primary decision on whether you're going to do a patent or trade secret, that's kind of the discussion that you're going to have, is whether it's easy to reverse engineer, and that you may want to choose something like a patent if it is easy to reverse engineer versus a trade secret to keep it protected in that respect. Okay. So let me take a pause and see if there are any other questions related to patents and trade secrets before I move on to trademarks.
Yeah, and thank you so much for explaining the difference, Hope. It's been really fascinating to get to see and learn. So a couple other questions we have. So one, going back to provisional patents, the question is there a cost difference between provisional and non-provisional patents?
There is, and there's a significant difference with that. So from a cost standpoint, let me talk about USPTO fees and I'll talk to you about attorney fees because they're different, right? They're two separate things that you'll have to pay for. So for a provisional application, and I probably should have looked this up, it's been a little while, but a provisional application, if you are a microentity, which you get specific discounts based on the size of your organization and how many applications you have filed. You're considered a small entity if you have 500 or less employees. You're considered a microentity if you fall below a certain income threshold, and you do not have more than 4 patents that you are listed as an inventor, or your company has not been assigned more than 4 patents, okay? So you're a micro entity. If you are a micro entity, you get an 80% discount on your fees, and a small entity, you get a 60% discount, excuse me. And so for a provisional application, that runs about $300, $350 for that application, for a provisional application. A non-provisional application will be about a couple of $1,000s. And so that's kind of the cost difference that you're looking at that. Now, from an attorney standpoint, all right, those costs are different and they can be more expensive. And that's why we have a number of different resources to be able to help you. From an attorney standpoint, for the non-provisional application, right? I've seen prices, and it's been a long time since I've practiced, okay? So you're probably looking at somewhere between $10,000 and $30,000. $30,000 tends to be the medical, the pharmaceutical patents, the cure for cancer, things like that. Those are the ones that you'll see that cost quite a bit more just because of the level of protection. But most patents will probably fall on the lower end. And so depending on the type of patent that you have, that may be what you are looking at for the upfront cost of the patent to be prepared. Right. All right. Any other questions, Megan? Okay.
Oh, I'm
All
sorry.
right. Let me,
Sorry, hope we do have one other. I apologize,
okay.
I was muted.
That's
So we
okay.
have another on provisional patents. So the question that Paige asks is there any automation or technology solutions being considered or which exist currently? She says she recently submitted the response for the USPTO RFI for technology solutions for patent filings.
So that's a really great question. We, like everyone else, are in the process of integrating AI into our systems and trying to figure out how we can increase productivity using AI. And so within the USPTO right now, we have already integrated AI into some of our search systems. And so it allows for our patent examiners to be able to search to see if something has already been patented before more efficiently. So patent examiners are utilizing that as part of the first step of their search and their evaluation on a patent application. They'll take the results and kind of evaluate it to determine if that is actually the results that they want, or they need to go back and do a different search to see if there are other things that are out there to be able to help them in evaluating the actual patent application. On the trademark side, as well as the design patent side, some of the things that we are considering is looking at how the pictures that are coming in. All right. And so trademarks, which I'll talk about in a minute because they're logo based, right? And design patents, ornamental features, they are photo based, right? And so what we're trying to figure out is comparing the photos or the drawings, as we call them, or specimens for trademarks, and compare them to what is existing already out there to see if there's something already out there. And so we're kind of using some of those tools on the trademark side. So there are a couple other things that we are obviously always going to be considering as we are continuing to use or look at different technology to help us be able to improve the productivity across the board. Okay, let me go into trademarks and copyrights, and then I'll take a quick break after that because I know that usually there's a lot of questions related to trademarks and copyrights. And so if you are a business owner or you are thinking about becoming a business owner, you have at least one intellectual property bucket in your wheelhouse, and that is a trademark. A trademark is what we call a source identifier. It tells you who is providing the good or service. And every organization or every company has at least a name for that company. And that name is how people know who you are and what products you are providing across the board. Now, a service mark is a subset of a trademark. And so a service mark is just another identifier. It's specifically related to services rather than products. But a service mark is a type of trademark. And so what are the common types of trademarks? So there are two of the most common types of trademarks are the words or what we call a design. Oftentimes you might consider that as your logo. And so you can actually trademark or apply for a trademark for the word like Starbucks, Nike, or Target, or the design, which is the mermaid. Actually, I heard someone say it was a siren. It's not a mermaid, it's a siren, sorry, from Starbucks. The Nike swoosh symbol, or the bullseye that you see from Target. What the source identifier tells you is what product or service that they are providing. So if you want a cup of coffee or a frappuccino, you know that you are going to go to Starbucks and you are going to go and get that particular product. What you also know is that you're not going to go to a Nike store in order to go get that cup of coffee. You'll go to a Nike store or you'll see the Nike brand And you know that you're going to be getting some sort of sports apparel or sports equipment because that is what Nike provides. Additionally, the Nike slogan, right, just do it, is also a trademark as well. So when you see that in association with sports products, you know that it is associated and it is produced by Nike. Target, same thing. If you want to go and buy a computer, you are probably you are not going to go to Starbucks or to go and look for the Nike symbol. You will likely go to a Target to go and buy a computer because that's the type of products that Target provides. Source identifier. Other things that can be a source identifier are colors. So you see here on the left, Tiffany blue, right? What does Tiffany provide? It is jewelry. UPS, brown. They are going to be mailing or delivering your packages or your letters. John Deere, right? The green against the gold. You know that John Deere is going to be providing tractors and other things, right? Yes, I'm pretty sure that's it. Sorry. But all of these things are considered trademarks as well. Smells can also be considered trademarks. Play-Doh, can everyone smell Play-Doh now? They have a very distinct smell. And so if anything that is clay-like, right, that you could build things with, it has a smell. If it has the same smell, then it's the Play-Doh smell. This is another example of a lubricant. It is a grape lubricant, and it's for engines to make the exhaust smell in a strawberry, cherry, or grape. In this case, it's grape. They also have the strawberry and cherry as well. And so something that you can include. Sounds, right? The Darth Vader breathing, as well as the lightsaber. The NBC chimes, NBC. That is also a source identifier. You know who is providing the product and what kind of product or service you're going to get. Buc-ee's recently applied for a sound mark, and it's the mark is brisket on the board, right? And so if you're at a Buc-ee's and you hear brisket on the board, you know that is associated specifically with Buc-ee's and what they are actually going to be providing you. The last bucket is trade dress. Trade dress is the look and feel of the shape of certain things. So the Doc Martin, the thread on the yellow thread on the bottom of the boot is distinctive of Doc Martens. The Hershey Kiss, whether you see it in the actual wrapper itself or the actual Hershey Kiss outside of the wrapper, you know what the name of that is. It's a kiss, right? You know what that chocolate is, and you know who made it. Hershey, at the end of the day. The Apple Store, the white and then the teak look, the boxy look that they have throughout their entire store, even without the Apple symbol that you see up there. You know that when you see that, that is considered an Apple configuration. And then the Coca-Cola bottle. Now, the Coca-Cola bottle, as you'll notice, this is a source identifier, right? Even without the name, you know who has made this product. But if you'll recall, it can also be protected by a design patent. And so Coca-Cola actually applied for both, right? The design patent as well as a trademark in order for it to be protected under the same thing under two different buckets of intellectual property. Okay. Let me jump into copyrights and then I'll stop again, like I said, for questions. So copyrights. Okay, so a copyright is an original work of authorship. There has to be an artistic component to it, embodied in a tangible medium. Examples of copyrights tends to be songs, books, movies, sculptures, right? All of these they are an original work embodied in a tangible medium, whether it's saved on an MP3 player. Are MP3 players still around? But anyways, MP3 player, whether it's on film, right, for movies, or it's in a book, or it's embodied in a stone, right, for the sculpture. Any of these things are protected by copyright. Now, copyrights are not granted by the U.S. Patent Trademark Office. They are granted by the U.S. Copyright Office. But the reason that we talk about copyrights is a couple reasons. One is it's one of the basic buckets of intellectual property. And then the other thing is that we at the USPTO are the advisors on all things IP to the President of the United States. And so as a result, copyright is something that we often do discuss and advise the president on a regular basis, right? Here's a couple other examples of copyrights. And then I am actually going to take a pause here, but right here is kind of an overview of everything that I just talked about, what's protected, some examples, how long they actually last. And so I'm going to leave this up here while I take a couple more questions. Megan, you're on mute if you're still there.
Yes, no, thank you. So I'm not seeing any new questions coming into the chat for the time being.
Okay,
so
perfect.
I think, yeah. Oh, looks like one just popped in. So a question now is content submitted to YouTube, for example, automatically copyrighted?
Yes. So the answer is yes. So it has to be an original work, right? A new work. And then once it's submitted to YouTube, right? YouTube has some sort of server in the background that saves that content. So a copyright exists once it's saved onto that server. Now, you don't actually have to apply to the US Copyright Office for you to get a copyright. But there are a couple of benefits that are associated with that. You want to apply for copyright protection if you ever want to enforce in the courts. And so in order for you to enforce your copyright in court, you actually have to have a copyright. If you want to prevent, for example, a shipment of goods from coming in to the United States, and you know there is a counterfeit or there is a knockoff or something that is going to be coming in, then you have to submit your copyright registration or your trademark registration, actually, to the Customs and Border Patrol, and they can stop that shipment from coming in. The other thing is that when you do sue in court, you have more damages that you can actually get if you do have a copyright registration. So again, very observant. Copyright exists once you save it onto that tangible medium. You don't actually have to register it, although it is recommended for you to register it with the US Copyright Office so that you can get some of the benefits of the copyright.
All right, and then another question is, can user interface be copyrighted or trademarked? For example, AR for mobile.
Okay, so the user interface in it of itself, right? The artistic screenshot, let me just say that, okay? That can be copyrighted, and oftentimes it is itself, right? Copyrighted. So yes, you can once it's saved into a tangible medium, which it usually is. From a trademark perspective, you might be able to copyright it. You might be able to trademark it, but the key thing is that it has to be a source identifier. So when you see that user interface, right, if you see it, someone has to be able to say, oh, that is made by Hope's AI company, for example, all right? And so that there has to be that tie. So if you're able to make that tie in order for that image to be associated with, the source identifier, then you can trademark that.
Awesome. And then a follow-up to that is, or he mentions it's a navigable interface.
So that's a really good question, right? So when it comes to copyright, right, that a lot of times from a software for that video game standpoint, you're going to copyright the whole thing, right? The whole movie, the whole navigation, all the screens that are associated with that AI interface, right? So that can be copyrighted, right? So a lot of people do, right? You see that, like I said, as the example of a movie or a DVD, right? That whole series is all copyrighted. So that's something that you can. For the trademark, again, it's the same question, right? And so you just need to make sure that whatever you're submitting in, it is the source identifier, whether it is that single image, right, of one particular scene. I think it's more challenging if it's the whole navigational, if you're trying to trademark every single scene. I think that there is going to be a question on whether that could be the source identifier. Most of the time, people are just trademarking the logo that is typically going to be at the bottom or the name of that AI interface. Most of the time, that's what people are going to be associating the trademark with.
And Hope, we are almost at time. You've done such a fantastic job going so thorough into all of these different types of intellectual property. So we've had so many questions rolling in, which is fantastic. So a real testament to you, but I think we have time for maybe one or two more questions, if that works.
Yes, but if you don't mind, I want to go through real quick the resources
Yes.
because I think that this is going to be really important. And so all of these things can be found at the resources I'm going to talk about can be found at USPTO.gov. And I apologize, I'm going to fly through these. We do have a newsletter that you can sign up for that you can get on a regular basis. We have a website that connects you to all of our startup resources. We have classes that you could take, they are free. We have an 8-part series. One of them is a path to a patent. We also have the trademark equivalent. We have 1-800 numbers that you can call if you're in the process. We do have help for searching if you ever want to come on site or to call us to be able to do some search. Trademarks is the class that I had just mentioned, an 8-part series equivalent to the patent one, but it's called the Trademark Basics Boot Camp. And we also have a 1-800 number for trademarks. Patent fees, I think I talked about this, the 80% reduction on the patent fees for microentity. And then this one I definitely wanted to touch on. We do have attorneys that we work with who volunteer their time to be able to help prepare patent applications. So if you fall below a certain income threshold, then you may be able to qualify for a volunteer attorney to help you. In Texas, it is Texas Accountants and Lawyers for the Arts. We have partnerships throughout the entire country, one for each state. So all of that information and their contact information can be found on our website. We also have clinics, which is law students supervised by practicing attorneys who can also help you on both the patent as well as the trademark side. In Texas, we are very lucky to have 4 law schools to be able to provide those services to Texans. And so please utilize their services. There is no income or salary threshold for them to help you. It's just note that they are law students, but they are supervised by practicing attorneys. The other resources, I know that you're going to get the slide deck, but you can get that information. But I did want to touch on a couple of those resources. And as always, you can reach out to us later on.
That is perfect. Yeah, thank you so much. Thank you for touching on those resources because I know that's very important, especially for our innovators and startups and just being able to take advantage of those. So it sounds like your website is the best bet. As you mentioned, the attendees will get the slide deck and all those resources are in there, which is also perfect. And then again, so that was the next question. For those who have questions that we unfortunately didn't get to or can't get to on this call, the best way to be in contact with you or someone from the USPTO, what does that look like? Or how will they be able to reach out?
Yeah, so please reach out to this website, southwest@uspto.gov. That is monitored. And so if I didn't get to your question, please send it to there and then I can respond to it directly after this presentation.
Right. Perfect. Well, I think we're good then for now. Thank you so much, Hope, for your time and for sharing. This has been absolutely wonderful, and you're such a wealth of knowledge. So I know everyone has really thoroughly enjoyed it. And I'll make sure that our attendees get the slide deck and have those resources as well. And thank you so much for the information. Is there anything else that you would like to share?
That is it. Thank you, Megan. And thank you, Vikram. I think he's logged off, but thank you for the opportunity to connect with everyone here.
Perfect. Thank you so much for joining us. And for everyone else as well, to just keep a lookout as we continue to do more innovation and investment focused webinars and workshops, always really looking to see what we can do for our community. So thank you. Thanks so much and have a good one.
Thank you.
Appreciate it.